If your company or business is in a dispute, it's most probably a commercial dispute. Now, commercial dispute resolution is the sole goal and purpose of several courts all over the country. The first court is the Commercial Court in London, which has been set up to resolve commercial and mercantile disputes, um, which can be significantly complex. But this court tries to resolve these disputes effectively, expeditiously, and justly. The second court I'd like to talk to you about is the London Mercantile Court, which typically deals with less complex and smaller value claims than the commercial court. The London Mercantile Court is also located in the very well renowned Rolls Building in the Royal Courts of Justice. The mercantile courts of the High Court District Registries are the regional equivalent of the Commercial Court in London. However, these are in places like Bristol and Birmingham and allow businesses who are not based in the capital to access justice and access the courts in a more convenient venue for them. One of, in my opinion, the most interesting courts is the Chancery Division of the High Court, which hears high value equity claims and technically falls under the Business and Property Division. So you can imagine high value claims for properties where there's a dispute, contentious probate, but as well as probate matters, the Chancery Court also deals with commercial property and intellectual property disputes. Since the reforms to the civil procedure by Lord Jackson and Lord Wolfe, the courts and the judiciary of England and Wales have made it very clear that you must settle your claim outside of the courts if it can be done. So litigation should be avoided where it can be. This has resulted in a global phenomenon of arbitration. Globally, there are satellite centres of the London International Financial Centre and arbitration centres such as the Dubai International Financial Centre to resolve disputes which can be resolved at arbitration stage rather than litigation. Now, if there is an express arbitration clause in the shareholders' agreement, for instance, then arbitration is must be complied with. It is a compulsory method of dispute resolution. Even if there is no arbitration clause, if a party brings a claim before the court without attempting to settle outside, without attempting some form of ADR, the court may turn around and ask the party, have they attempted arbitration? If not, why not? So litigation is the last resort. For many claimants, this is bad news, as arbitration is a costly exercise and it's not cheap, and could be seen as a hurdle, an additional expense for those who believe their disputes cannot be settled by an arbitration award.